To invite Judge Rader to teach us the recent development at the federal circuits. So let's give a warm welcome to Chief Judge Rader.
First, it's an honor and privilege to be here at Yunlin again. I am also very happy that I am here with your Professor Wang. She is a longtime friend of mine, and I have great respect for her work. I'm going to, which button? There we go. I'm going to talk to you about one area today. Is that up? Yes. I'm going to talk to you about how you calculate damages in IP cases. And we're going to start with a case that I want you to decide. Do I need to translate this, or they're following?
They're following.
Okay. This case was first handled in the House of Lords in Britain over 100 years ago, as you will see from the example. It starts with a horse that is not being used. The owner actually does not like its horse very much. It leaves the horse in its stable. And finally, a young delivery boy sees the horse is not being used, and he takes the horse to do his deliveries. Notice that the horse is a very sad horse. It was not well taken care of. It is a abused horse. He takes it for his deliveries, but he feels sorry for the horse, and so he brushes the horse. He feeds the horse. He changes the stable hay for the horse and makes the horse into a noble steed. Steed is an English word for a very fancy horse, a happy horse. But now the horse owner comes and he says, "You owe me money for using my horse without permission." The delivery boy says, "I used your horse without permission, but I did not cause you any damage at all. As a matter of fact, I improved your horse. I made your horse happy when it had been sad. I changed your horse from a decrepit animal to a noble animal. Therefore, you have a better horse today, and I should not have to pay anything because I did not harm your property." The question you have to answer is, who wins this case? How many think that the delivery boy wins because he has improved the horse and has not damaged the owner of the horse? How many think that? You have to vote for either the delivery boy or the horse owner. The horse owner is going to say, yes, you go ahead. She's going to explain in Chinese.
现在是一个寓言故事，他现在不是讲说有人专利不用的时候啊，那别人用了之后呢，这些专利鲨鱼、专利这个蟑螂，他们又去诉讼这些人，要求他们付钱。可是事实上一开始他没有实施，是不是就没有收入？没有收入就没有损失，那怎么可以后面再去跟人家要这个费用？所以现在他就说呢，那现在你把这个不用的专利弄得赚钱之后啊，这个拥有者跑来要跟他要钱。现在法官问你们说，那现在这个专利的拥有者，就是这匹马的拥有者，可不可以跟人家要钱？他说你同意的举手，不同意的举手。同意的举手一下，快点举手。
Okay, how many now think the delivery boy wins because he caused no damage? Remember, the horse had never been used and he used it for the first time. How many think the delivery boy wins? 1, 2, 3, 4, 5, 6, 7, 8. Okay, many. How many think the horse owner wins because they used it without permission? 1, 2, 3, 4, 5, 6, 7, 8, 9. We are about even. Shall I tell you the winner? I'm going to let the suspense build for a moment. The answer is the delivery boy does have to pay the damages, but he only has to pay the rental value of the horse. And this is the key. He will pay the rental value of the horse which he actually used. Pay the rental value of a very sad horse. The owner will want him to pay the rental value of a very expensive horse, but that is not correct. Actually, this is often the problem in the law, is determining the actual rental value of the property that is used. I'll give you one more example, and then Professor Wang is going to make me quit. Assume I invent a new chip for this phone. The chip makes the phone work twice as fast. But it is a very tiny chip. It only costs 5 cents to make the chip. Now I have to ask you another question. How many patents are in this machine? Professor Wang says over 1,000. How many do you think? 200. Ed says much more. But Professor Wang is close to correct. Actually, there are probably about 600 utility patents. Those are the hardware inventions. If you count design patents on all of the apps, then it goes up to over 1,500 patents. Remember, I have invented just one small chip. That's one patent out of 1,000. How are we going to compute the damages if someone copies my invention and uses it in their cell phones? Notice, if you were in my class, we would talk about this hypothetical for many hours, because on the one hand, this is only one patent out of 1,000. If a manufacturer had to pay a vast amount for every patent it uses, it could not go into the business of making smartphones. It would cost too much in license fees. In rental value, you would have to rent too many horses to make it valuable. But on the other side, I told you one fact that suggests my invention is worth quite a bit. What did I tell you? I said this, yes, you're right, Professor Wang, it makes it work twice as fast. That means, why do we buy these? Because they work faster than other phones. They can give us access to the internet faster. They communicate faster, and we can compete in the marketplace faster. If I had hours, I would tell you how much you are competing with every other law student in the world today. But I don't have time to give you that lecture. But you buy these because they are fast, and the fastest one gets the most customers. In economic terms, we would call my invention a demand driver. People are driven to buy the whole phone because of my invention, which makes it faster. Now notice the problem. Because people buy this phone for its speed, I should be able to claim a large percentage of the value of this smartphone as the compensation for infringing my intellectual property, because my invention is the reason people buy your phone. So, as an economic principle, my invention deserves vast protection. But remember, if we protect every invention to that degree, we will not have any manufacturers of smartphones. This teaches us, this example, how careful we must be to ascertain the actual value of each invention. My invention may be worth a 10 or 20% rental value. My invention may be the very powerful horse. Most of the other 500 or 600 inventions in this are most likely of less significance. But the courts must learn how to do it. If I had time, I would tell you about many cases that deal with these principles. Let me just tell you two important facts. The first thing you must learn is to set the proper rental value. You do that by comparing the claimed invention to other inventions that are similar that have been licensed before. So the courts must do an examination to find comparable licenses. We want to find out what technology that is similar to the claimed technology is rented for in the market. That is not always easy. We have several cases where the court makes a great effort to find comparable licenses so they can set the rental rate. The other problem in this area is deciding what part of this machine is the base that we use to calculate the royalty. We could use the whole machine worth $400 or $500. We might also, the invention might just pertain to the screen or just pertain to some portal that connects to other technology. So you have to ascertain what is the proper base. That requires, again, an economic analysis of what part of this machine is the demand driver. It's a question of economics. You need to invite economic experts to testify as to the value of various components. Well, my time is probably up, but let me tell you that this is an important part of intellectual property litigation, is finding the actual value of the claimed invention and making sure that you're getting the right rental rate for a very sad horse or a very noble horse, as I mentioned in my initial example. You will confront this issue often through your careers. I hope you will remember the story of the horse and the story of the chip, because they illustrate the principles of setting damages in patent cases. Thank you.
我们非常谢谢我们Chief Judge Rader， 他刚刚很快讲一下，就是说他先用那个马的例子来告诉我们说，其实拥有人是可以去要权利金，然后接下来很快的时候，他说那怎么去算这个权利金呢？那刚刚是不是有说专利有很多，这样那到底它的价值在哪里？用市场的方法，或者是用这个技术的这个高低？所以呢，他说今天给我们的这个案例，让大家发人深省在你的心里去想想，以后这些事情应该怎么做。因为时间的关系，那我们thank you Chief Judge Rader again, thank you.